Okay, I think we're going to get started here. Just wanted to say hello. My name is Will Tiao. I am the organizer for the LA Multifamily Investor Networking Group. I'm also the director of of the commercial real estate division at the Collective Realty, which is based in West Hollywood. Our broker owner, Anthony Bullen, whose picture you see on here as well. He's unable to join us today, but I know he'd like to be here because this is actually a big webinar for us. And one of the reasons is that this is actually our 4-year anniversary. We started this speaker series 4 years ago this month, and we're now up to 962 in our group. So we're very close to 1,000. To kind of celebrate and get us there and get us to that thousandth member, we're going to be, giving away a prize to the 1,000th member that signs up for our group. Or if you recruit that 1,000th member to come into our group, we'll be giving away a prize. So if you guys are interested, please get your friends and anyone you think is interested in the multifamily, and learning more about multifamily, whether to purchase, to sell, to manage. As those of you know who have been with us for the last 4 years, we cover the gamut when it comes to anything dealing with multifamily investment, including today's seminar on eviction, on the eviction laws and what's going on with that. We always try to stay timely. We always try to do something that has to do with for multifamily investors, and obviously it's a changing landscape that we're dealing with, and we'll talk about some of those things today. So once again, if you know people who are interested, please have them sign up. We're trying to get to that 1,000th member and have a little, online party afterwards. So let's talk about some of the things that's happening in the multifamily landscape today. First thing I'm going to do, I'm going to share an article that I saw online. Just a second. It was in the LA Times, and let's see here, not showing for some reason. Sorry, got a few technical issues. There we go. There it is. Okay, so some of you may have seen this article. It was in the LA Times 2 days ago, saying that rent is starting to drop. And for those of you who have been attending this speaker series that we've been having, none of this information should be new to you. We have been discussing this for the last few months about how, obviously, since the pandemic has started, that there has been a drop in multifamily rents. And what the article goes on to say is exactly what we have been discussing in the speaker series, which is that Class A luxury buildings, particularly those in downtown, in the mid-city area, they are seeing real serious drops in their in their percentages. So for Class A properties, they say they've fallen 4.3% from the start of from the beginning of March. I can say personally, like one of our units that we manage is in downtown. It's in a luxury building. It's been vacant now for the last few months. The tenant was working in the entertainment industry, was stuck up in Canada, could not get back. So she decided to get out of her lease. And so we've been trying to rent this property out. At this point, we're offering 2 months free rent. And that's standard, what we're seeing downtown. We're even possibly going up to 3 months free rent. Once again, this is not unstandard for Class A buildings that we're seeing. However, the further down you go in the class, So Class B properties, rents have dropped 2%. Class C properties, usually the oldest buildings with the fewest bell and whistles in common areas, fell 0.2%. So that's almost nothing. So the vast majority of the buildings that we manage at TL Properties, which is our top property management company, we manage primarily B and C class buildings. And I can tell you that that is pretty much precisely correct. This is why we've been saying this now for months, that we are seeing a drop in rents, but for the A class buildings, we're seeing a higher drop because frankly, they overbuilt Class A buildings in the city, right? As we all know, like there's just a lot of luxury properties and not enough people who can afford those properties. However, the B and then the C class buildings, which is frankly more middle class workforce housing, those numbers are not going down. And we've always argued that, you know, it's one of the reasons why we like this asset class is because we find it to be much more stable. And frankly, as we all know, previous to that pandemic, the major crisis was a housing crisis. And they are not building enough B and C class housing in this city. And that's why you still see those rents falling, but just slightly. Because at the end of the day, there are still people who are interested in renting those properties. So that's what I would say with regards to that. Now, with regards to sales, let's talk a little bit about what we're seeing in the market now. By the way, I forgot to mention this. We obviously have a chat room, so feel free to put your questions in there, comments. We also, this is kind of an open market. We're going to be talking a little bit about some of our listings. And if people have wants and needs, we highly encourage people to put out there what they're looking for. If they have something, to put it out there and to share their information. Deals have been done in this forum, and we highly encourage that. So let's talk about the market right now. Let's talk a little bit about the sales side of things. So definitely sales volume is down, but partly that has to do with there aren't as many listings out there. Now, that said, we're starting to see a slight uptick in listings, and I think some people might argue that there are some landlords that are now under stress, right? Some of those landlords, particularly I would say on the commercial side, right? Retail, office, hotels, some of those landlords are under tremendous stress because some of them have not had a lot of, on the commercial side, what I'm hearing anyways, on the retail side, is that rent collection is around 50%, which is shockingly low and not surprising, right? Given that so many businesses are closed during this pandemic. So commercial landlords, a lot of them are having a really tough time right now. On the multifamily side, so for ourselves, on the multifamily management side, our collection has been around 92%. And what we're hearing is that a lot of people are in that same boat. That generally speaking, on the multifamily side, collections has been around 90% or above. Now, you might see different numbers in different areas of the country. You've probably been hearing a lot of news about there's going to be this huge wave of evictions and whatnot. So in different parts of the country, I can't say what those numbers are because I think it varies city to city, county to county. But I'm talking specifically about Los Angeles and LA County, and which is where our properties are, and I think the vast majority of the people here have their holdings. And generally speaking, we've seen 92% of collection. Now, I will say that 8 to 10% is not evenly distributed. For example, we had a management client that had a duplex in Highland Park. Neither tenant was paying. So when that happened, they were basically forced to sell. So those things are happening right now. We are seeing that basically turnkey properties, basically properties that have already been basically already repositioned, like they've either been remodeled or, you know, they're basically at top of market. Those properties for sale are not moving as quickly. And in fact, some of them are just sitting there. Value add properties, properties that need work, but that there's value to them, those properties are moving. And I can see that even amongst my own listings, and I'll give an example of that. So let's share my screen again here.
Will, did you want me to go now or later?
Just a second, sure. Monisha. I'll introduce you in a second. So here's an example of a multifamily sale that we have. It's a 30-unit property in Boyle Heights. These were all single, it's an SRO building that's a single resident occupancy, which is to say shared bathrooms. And this is in the heart of Boyle Heights. And 25 of the 30 units were being delivered vacant. We estimated that if they were delivered at market, the market GRM would be an 8.76 and a market cap of 9. And if, for those of you who don't know what a cap rate is or a gross rent multiplier, GRM, is, feel free to contact me afterwards. I'm happy to go over those terms with you. But those are very strong terms for anybody who doubts that. A 9 cap, 8.76. Now, we offered at 2,995. We had multiple offers. We're in escrow, well above asking. So I would say that for value add properties, those things are still moving very quickly. I have another couple properties here. These are more turnkey. So let's see. Sorry, stop that share. Monisha, are you seeing the 5 turnkey units in Westlake? Is that right?
Yes.
Okay.
Yes.
So this is a 5-unit in Westlake, which is just south of Echo Park in Silver Lake. It's a 4-plex in the front and a single house in the back. The 2 top units are both 3-bedroom, 1.5 baths. The bottom units are 2-bedroom, 1 baths. And the back unit is a 3-bedroom, 2-bath, 1,500 square feet. There's 5 garage spaces that are being rented for extra income, and 5 driveway spaces. So total of 10 parking spaces. This one is turnkey. It's been all the bells and whistles with it. It's been completely renovated. Those are some of the numbers in terms of rents. And the cap rate is a 5.43 when all 5 are rented. 4 of the 5 currently are rented. We currently have this on the market for 2.495. So this is kind of an example of a turnkey property. Okay, I'll share one more. And Monisha, do you see the 5 units in Silver Lake? Okay. So this is also a 5-unit property in Silver Lake. These are all 2-bedroom, 1 baths. And once again, it's also turnkey. What's interesting about this one is that it has a 3-car garage that can be, that has already been, the seller has already gotten permits to turn it into an ADU, a 1-bedroom, 1-bath ADU. So there is some value add potentially here. Same thing, separately metered for gas and electric. They've all been renovated, with all brand new appliances, lighting, electrical, roof, everything. You can see some of the numbers here. Same situation for the 5 units, for the 5 2-bedrooms have been rented. The 1-bedroom, 1-bath, like I said, is currently a 3-car garage, but it is permitted to be turned into a 1-bedroom, 1-bath. We're listing this at 285, which gives us a 5.43 cap rate and a 14.35 GRM. That's assuming that you turn that 1-bedroom into an ADU. Without the ADU, I believe the cap rate's about a 4.75. So as of right now, we're not seeing a lot of decreases yet in terms of prices, but that may be happening. There may be some pressure on owners to start decreasing prices. Then again, with these types of rents, right, a lot of owners decide to just hold, right, because those are pretty good rents. So if you can get top of market rents, sometimes they'll just hold and they'll just wait to see that the wait through whatever recession, however long this recession is going to last. So there's that. So let's get to our topic today and our speaker. So I'm going to open up her slideshow. So today's speaker is Monisha Coelho from the Alvarado Smith Law Group. And she's going to be talking about multifamily properties, eviction, and rent increase moratorium. Monisha is a real estate litigator who represents developers, tenants, landlords, homeowners, and lenders in a wide variety of commercial and residential real estate disputes. She's a partner in the law firm of Alvarado Smith in downtown LA. She is licensed to practice law in India and advises clients on cross-border U.S.-India real estate and business transaction litigation. I've now known Monisha for, I would say, a better part of a year. Super smart, really great lawyer. I was really happy that she agreed to come on today and give us a presentation. So, Monisha, please introduce yourself.
Thank you, Will. Do you want to click the play from start on the slideshow?
Yes, I can.
Sweet. Thank you. Okay. Next slide. The next. Thank you. So hi, everyone. My name is Monisha Coelho. I am a real estate attorney, and I essentially resolve disputes of all kinds in the real estate market: title fraud, lender disputes, disputes between developers, borrowers, neighbors, homeowners associations, whatever the disputes are real estate related, I handle those. So right now, due to COVID, there is a whole range of rent and eviction and rent increase moratoriums in place. And I want to run through with you what's currently in place in the LA County and city area. So the moratorium, was enacted. There were multiple ordinances issued, and then the moratorium was, one of the final ones came through in the end of July. So even though it came about in the end of July, it is retroactively in force from March 4th onwards and currently until September 30th, unless it's further extended. So the moratorium against eviction of tenants and rent increases applies to residential and commercial tenancies, mobile homes, and properties used as commercial storage. And they apply to all cities and unincorporated areas in LA County. Next slide. So what is the prohibition on commercial and residential evictions right now? So what the moratorium says is that you cannot evict, terminate a tenancy, serve an eviction notice, file an unlawful detainer, or require a tenant to vacate a property if it's for non-payment of rent, if it's a no-fault eviction, or if it's a nuisance due to COVID because of the presence of unauthorized occupants and pets on the property, or because of a nuisance to the number and noise of unauthorized occupants and pets on the property. With respect to the non-payment of rent, you cannot evict a tenant for non-payment of rent, if the tenant tells the landlord that the tenant has been financially impacted due to COVID and gives the landlord notice within 7 days of the date the rent is due, unless there are extenuating circumstances. And the extenuating circumstances includes if the tenant has COVID, a family member has COVID, and there are other health concerns related to COVID. And the tenant can give the landlord notice orally or in writing. So the tenant can just call you up or send you a text message and say, we're unable to pay rent because of COVID. And if the tenant does so, you may not evict the tenant. Next slide. So while those are the grounds for preventing, for which you cannot evict the tenant, you may evict a tenant if it is to protect the health and safety of occupants and neighbors. Also, if the tenant is unable to pay rent due to reasons that are not related to COVID, then the landlord may go ahead and evict the tenant. So certain other aspects are impacted by the moratorium. If you served an eviction notice on a tenant, and as of March 4th, the eviction notice period had not expired, then that eviction period is told during the moratorium. If you served an eviction or a termination notice during the moratorium, that is anytime after March 4th, if you served an eviction notice or a lease termination notice, it's null and void and is of no effect. And the last thing to note is that leases that ended during the moratorium will not, even though by the term of the lease it ended during the moratorium, the lease will continue until the moratorium expires. Next slide. So in addition to the ban on evictions, there's also a stay on pending evictions. So if a tenant provides a landlord notice that the tenant is impacted by COVID, and because of any of the reasons we discussed above, then the landlord must stop the eviction efforts and must dismiss an unlawful detainer. So even though a landlord dismisses the eviction, an unlawful detainer or an eviction lawsuit that he has filed against the tenant will not be deemed the prevailing party. It would be deemed a voluntary dismissal by the landlord, and the tenant is not entitled to any attorney's fees or costs of filing the lawsuit, etc. Next slide. Well, you might have to hit enter. So a tenant has to give a landlord notice telling the landlord that the tenant is not able to pay rent because of a financial impact on the tenant due to COVID. So now what is a financial impact on a tenant due to COVID? So if the tenant has a substantial loss of household income, revenue, or revenue due to business closure, enter. Well, if you can hit enter, yeah. You can keep hitting enter. So these are the reasons that are deemed to be a financial impact on the tenant due to COVID. So like I said, the first one is a substantial loss of household income and revenue due to business closures. If there was a loss of wages or layoffs, if the tenant had extraordinary medical expenses, if there were other substantial losses of income, earnings, and revenue due to COVID, and all these losses were greater than what would have been reasonably expected if COVID had not happened. Did I say that correctly? So yeah, if the losses are greater due to COVID, then that will be considered a financial impact on the tenant. If the losses are just seasonal and what the tenant normally experiences during this time of year, that will not be considered a financial impact on the tenant due to COVID. Next slide. So how does the tenant do this? So the tenant has all these loss of wage, loss of revenue, loss of income. The tenant tells the landlord, I have this problem financially, I cannot pay my rent because of COVID. So there are different ways where a tenant may certify this to the landlord. So for a residential or commercial tenant that has less than 9 employees, the tenant may self-certify that they have been financially impacted, which means the tenant does not need to provide any documents to support this. The tenant simply has to give a written, signed self-certification to the landlord saying, excuse me, I have been financially impacted by COVID, and hand that notice in, or that letter into the landlord. The Los Angeles County Department of Consumer and Business Affairs has a form, a self-certification form that the county has developed that is on their website. And the city and the county are encouraging all tenants to use that form to self-certify, or landlords can provide a copy of that form to tenants to self-certify. Next slide. Sorry. So for commercial tenants with 10 to 100 employees, the rules are a little more stricter as to how they have to document to their landlord that the tenant has been financially impacted due to COVID. So the tenant has to provide written documentation of the various reasons. Say we had loss of revenue, we had loss of business. The tenant has to then also include bank statements, gross sales receipts, proof of increased expenses, government closure orders restricting the tenant's business, and any other financial documentation that would show to the landlord that this is actually the financial impact that that COVID has had on the tenant. Let me just say quickly, I can see some questions in the chat. We'll run through those questions with me at the end of the presentation. Thanks.
Yes, I definitely will.
I'm going to try and not read them because they distract me. The other thing landlords are asking tenants are if the tenant availed of a PPP loan or an EIDL loan or got any other financial assistance from the city, the county, the state, or the federal government, because each of those governmental entities was providing loans, grants, all kinds of things, various different financial assistance to various businesses and homeowners. And so landlords are also asking tenants to include that information so the landlord can accurately assess the financial impact on the tenant. Thanks, Will. Next slide. And yeah, you can hit, great. So in the previous slide, the amount of documentation that the tenant needed to provide was based on the number of employees that the tenant had. So how do you count the number of employees? So first of all, the number of employees are counted as of March 4th. So the amount of employees a tenant had as of March 4th will be the total number of employees. If it's a sole proprietor, the number of employees includes the total number of employees at any business location of the tenant, including locations outside the county of LA. For all other tenants, the total number of you'll count the total number of employees by the total number of tenants' employees at any business location, including locations outside LA County, and also including employees of any subsidiary, parent, or affiliated entities. So if your tenant is, let's say, a school, and they have 3 schools all over California, you would include, and it's owned by your tenant, it would include then the employees at all these locations. For franchisees, and this I know doesn't apply to multifamily properties, but generally anybody that has a franchise, this, when they're counting employees, they do not include the employees by other franchisees that are separately owned and by the franchisor. Next slide. So the tenant is impacted financially by COVID. The tenant lets the landlord know. Depending on the size of the tenant needs to provide a certain amount of documentation. And the amount of documentation that the tenant pays depends on the size of the tenant, and that size is counted based on employees. So the tenant gives the landlord notice, the landlord can't do anything. Then we get to the point of how does the landlord recoup that rent and what is the status of rent. So first of all, the tenant is obligated to pay all rent that was incurred during the moratorium. It doesn't mean the tenant is obligated to pay it right then, but it is a debt that the tenant owes, a legal financial debt that the tenant owes to the landlord. It's not that the rent is waived, it's just deferred. The tenants are encouraged, the local governmental authorities are encouraging tenants to pay all or partial rent if they are financially able, and to pay all rent as soon as they are financially able. Next slide. So the landlord can accept partial rent payments without forfeiting their rights. So sometimes landlords are worried that if they accept partial payment, it will be deemed that they have now agreed to a lower rental payment with the tenant, and this new rent that the landlord is accepting is now going to be the rent going forward. But under the moratoriums that are in place, if the landlord accepts a lower rent, that's not going to affect any of the landlord's right, and the landlord can still go back to claim the unpaid amounts of tenant rent. Landlords can set up payment plans with tenants. And if the tenant pays rent on time, then the landlord cannot charge late fees, interest, penalties, or any costs to the tenant for paying the rent late. Hold on, did I miss a slide? Next slide, please. So how are tenants obligated to pay back the rent? So there are different time periods depending, again, on the size of the tenant, and it goes back to the number of employees that the tenant has, which is how the size of the tenant is determined. So residential and commercial tenants with less than 9 employees have 12 months from the end of the moratorium to pay back rent. So remember, as of now, the moratorium is extended until September 30th. If that moratorium gets extended until December 30th, then the tenant has 12 months from December 30th to pay back rent. As of now, it's 12 months from September 30th to pay back rent. And again, if it's a tenant with less than 9 employees, the landlord cannot demand that the tenant pay rent based on the landlord's schedule. Next slide. For commercial tenants, no, one back. Thank you. So for commercial tenants with 10 to 100 employees, the tenant has to pay rent back within 6 months from the end of the moratorium, and payments are in 6 equal monthly installments, but the parties can agree to an alternate payment schedule. Next slide. And then, for commercial tenants that have 100 or more employees, multinational companies, and publicly traded companies, there is no moratorium. So all their rent payments were due by June 1, 2020, unless landlord and tenant agreed to a different arrangement. Next slide.
Did I skip a slide?
Yes. There we go. So the prohibition on rent increases is this. So for tenants and for buildings covered by the rent stabilization ordinance, either for apartment buildings or for mobile homes, there can be no rent increase while the moratorium is in effect. If there were rent increase notices given prior to the moratorium, they will be told until the end of the moratorium, and told simply means that they're just delayed or continued until the end of the moratorium. Generally, for all properties, no, I'm sorry, this is still for rent stabilization properties. There are no new pass-throughs, interest, late fees, or unpaid rent that the landlord can pass on to the tenant. And the landlord cannot retroactively impose or collect such amounts after the moratorium. Next slide. So the government authorities are taking these moratoriums fairly seriously. And the moratoriums say that a landlord cannot harass or intimidate a tenant. And harassing or intimidating a tenant means threatening to terminate the lease or to evict the tenant, serving an eviction notice or a lease termination notice on the tenant, demanding rent, shutting off utilities, or other acts like that that are, landlords you can use to harass a tenant. Next slide. So if a landlord is doing any of these things, the landlord is guilty of a misdemeanor under the Los Angeles Municipal Code. And, it's a criminal violation. So the city attorney or somebody else can come after you. If it's the tenant, sorry, back one. The tenant has a private right of action, which means the tenant can file a civil lawsuit against the landlord, either during COVID or after COVID, claiming the landlord harassed the tenant. And any agreements that the landlord makes with the tenant, right? Saying, you will pay me X rent, or I can increase the rent by Y. If it violates any provisions of the moratorium, those agreements are void. And if the tenant sued over them, the court would hold those agreements void. Also, if the landlord tries to evict the tenant by filing an unlawful detainer, then the provisions of the moratorium become an affirmative defense for the tenant, and the landlord will not win in an unlawful detainer or in an eviction lawsuit, and the tenant will prevail. Next slide. So there's also a price gouging law in California, that is California Penal Code Section 396. And what is price gouging under the California law? So price gouging under the California law is the excessive and unjustified increase in the prices of essential consumer goods and services during a state of emergency. Now, over the years, various things have been added on to this penal code section. So in addition to essential household consumer goods and services like, medical supplies, PPE, basic household services, hotel rents have also been included under price gouging requirements, as well as increase of rents of certain properties. And so this provision also applies to landlords. So it is a criminal violation. And again, either the city attorney or the state attorney can come after you and file charges against you. The price gouging laws applies only to residential properties. And based on my readings of the various executive orders issued by Gavin Newsom, the governor, the moratorium has been extended through September 30th, 2020. Sorry, not the moratorium. The application of the price gouging laws have been extended through September 30th, 2020. Next slide. So under the price gouging laws, essentially the rent may not be increased by more than 10% during an emergency, plus for 30 days after the emergency is over. Rent increases greater than 10%. If there are rent increases greater than 10%, the landlord must prove that it was due to costs for repairs beyond normal maintenance, or that it was contractually agreed to by the tenant prior to the emergency. And the third thing the landlord cannot do is they cannot evict a tenant and then re-rent the property for more than the evicted tenant could have charged. And again, this provision applies during the emergency and for 30 days thereafter. And that's it. So there's me again in that picture, and I am happy to answer questions.
All right. All right. Thank you, Monisha. I have a few questions for you.
I hope they're easy ones, Will.
Well, obviously, there's been a lot of issues for us with regards to the eviction moratorium. We manage a few hundred units, and some of the information you gave is really interesting. Some of the stuff I didn't even know. So I'll give you some of our scenarios that we're dealing with. So I have one scenario where I do have I have a tenant who pre-COVID, so in January, had stopped paying rent. We got a judgment against him, and he was supposed to be locked out in March by the sheriff. However, COVID hit, and the sheriff stopped doing, lockouts on evictions. So therefore, he's been not paying rent since January. We're in August. He not only has not been paying rent, he's now illegally subletting his unit. Okay. So basically my client now has not received rent for about 8-9 months. He's down about 15K. And on top of it, the tenant is now making money on the situation. What are his rights? Like what can he do given the situation? Does he have any rights?
So yes, he does. Now, before I answer that question, let me just say, so this is a webinar, and any information I provide here is not legal advice, because, as attorneys, we have certain requirements and restrictions by the State Bar of California, and my firm has certain restrictions. So, and one of the reasons I say that is because I don't have all the facts, and we're kind of doing this on the fly. So I would be happy to talk to your client, your tenant, or to your landlord in more detail. But I will say this, generally speaking. The landlord can go back to court, right? Because his tenant is not covered by COVID. But then again, let me ask you this. Was there an order for him to pay rent or to collect rents or to deposit rent with the court?
Yeah. I mean, we had a judgment against him. Yes, for
no, I meant to continue depositing. So here's what you could do, and I'm going to send you a bill for this, because he could go back to court and ask the court for an order for the tenant to deposit rent, ongoing rent payments. The tenant will likely come back and say, I can't pay rent because of COVID,
right?
And the landlord's going to get stuck. But I think if the tenant is subleasing, you would have a valid basis to go back before a judge and say, the tenant is subleasing, here's proof of the sublease, and we want to be able to have either the tenant pay that rent to us or deposit it in court.
Okay. Now, another.
I know there was, sorry, I know there was a question in the chat.
Yes, I'm going to go over that right now. Yes. So it's from Mary Allen, who used to work with us and is now working with another property management company. Could you please clarify if these tenant protections are from LA County, and what are the differences in the city, county, state housing protections, and which take priority?
So I think that was in my slide. Maybe you took it out. Yeah, there's so much stuff in there. So I think right now, and let me say this, this is the single most convoluted piece of laws that I have seen. I did a client alert for my firm in May. I did a second client, I updated the client alert for my firm in July and the client alert is based on these eviction and rent increase moratoriums. And if you go to my firm's website, it's Alvarado Smith Law, and you hit on COVID resources, on COVID-19 resources, you will see the fact sheets that I prepared in May and in July. And I'm still confused, right? Because it is really, here's what happened. Normally laws that take years to pass were done in weeks, and people just put together a bunch of stuff and shot it out to the public.
Yep.
So even I have to walk back and go through the nitty gritty. But essentially, the city of LA is using the same moratoriums issued by the County of Los Angeles. Also, starting the end of July, the county said that these moratoriums will apply to every city and unincorporated area in the county. And I think that's in my slide. And if a city does not have a provision that's in the moratorium I discussed, let's say the city doesn't cover commercial properties or it doesn't cover mobile homes, then the county moratorium will apply. Or if a city moratorium says, a small tenant with less than 10 employees has to pay rent within 6 months, right? Then the county moratorium, which provides the ability for the tenant to pay rent within 12 months, that will apply. Right. So where a city does not have a provision, or it has a provision that gives the tenant less rights, the county protections that are wider and greater, those will kick in for the tenant. The state of California has governed or affected the rent increases and evictions largely by authorizing various cities and counties to come out with their own ordinance and rules, and through the price gouging statute, which is a statewide statute.
Okay, very good. And obviously, please keep in mind, like, as Monisha said, every city has its own jurisdiction, and some have rent stabilization ordinances and some don't, right? I live in Burbank. It does not have a rent stabilization ordinance. But next door, Glendale does. LA does, obviously. West Hollywood, Santa Monica, Beverly Hills, they all do. But Montrose doesn't, so depending on where you're sitting, but the county, as Monisha says, supersedes all local jurisdictions regardless, it appears. One question from the Q&A. Okay, it's not totally related, but does the speaker's practice include real estate construction contract dispute?
Yes, I do. All real estate disputes. I love real estate disputes.
Okay. Please continue to type in any questions you have either into the chat or the Q&A. Like I said, I've got a million questions.
I mean, if you have questions, feel free, Will. The one thing I want to point out is that the moratoriums are kind of separate from the rent stabilization. So for example, Culver City, before LA City had the moratorium cover commercial properties, Culver City was already covering commercial, right?
Right.
So each city has either not enacted a moratorium on rent and eviction increases, in which case the county's moratorium will apply, or the cities many cities have already enacted. Long Beach, Culver City, Azusa, a whole host of them, Anaheim, have their own eviction moratoriums and rent increase moratoriums, and you have to go on the city or county's website to check.
Now, you and I actually were discussing this question I'm about to ask yesterday, and we kind of got interrupted, but I think it's important for everybody else to hear. There's a question about whether or not these eviction moratoriums are even legal, right, by the Constitution. There's an argument to be made that this is a taking, meaning you're taking money from landlords and, in a sense, giving them to tenants. And there have been, I read a legal opinion, for instance, by a couple partners at Gibson Dunn, which is a very high-powered law firm, suggesting as much. What have you seen case-wise? What are you seeing in terms of those things? Because I know that there are lawsuits. I know the Apartment Association of Greater Los Angeles has a lawsuit against the city of Los Angeles, against their eviction moratorium. I'm curious what your opinion is of the constitutionality of some of these moratoriums.
So first of all, I would say is that as lawyers, we like to discuss and argue things and play the devil's advocate. So, you'll see lots of lawyers saying it's this, it's that. And, if they had a client who wanted the moratorium enforced, they would argue vigorously that the moratorium is constitutional because it benefits their client who's a gigantic tenant. There have been some other lawsuits that were filed against the city ordinances early on in April or May, and the courts have said that the city had its police powers to enforce these laws. And I think what the judges are doing, again, some of them are just are initial preliminary proceedings, right? Because you file a lawsuit, it goes all the way to trial, which is when a final determination is made. So lawsuits are being, which happens in a year or so, and now it'll get extended. But right now, so the cases are being filed, you're just getting a preliminary decision right now, right? And in those preliminary decisions, the courts have been upholding ordinances and rules issued by the city and the counties. And the reasoning is that it is a state of emergency. People are dying. There is a severe health crisis. The court cite to CDC requirements, to the state of emergency declared by the president at a national level, to the state of emergency declared by Gavin Newsom at the state level, to the states of emergencies declared by the city of LA, the county of LA, and have said, you know, it is a reasonable exercise of the city and the state's police powers, or the ability to manage the state or the city or the county during an emergency. You know, having said that, and also if you look at the ordinances that the County of LA issued in the end of July, which is kind of the basis of what will be enforced going forward, the ordinance spends a page and a half almost documenting the reasons, and homelessness, preventing rampant homelessness in the city, assisting small businesses and business owners, assisting individuals who have lost jobs. So my sense is the reason the city included all that in the ordinance was so that when, not if, when someone challenged it in court, the city had enough reasons on a valid basis. That said, I think it's destructive to the landlords to not get rent for a year. And, you know, we have clients who are both landlords and tenants. And, you know, while, right. And so while, you know, the landlords have the issue of dealing with their lenders, right? So a lot of commercial loans or multifamily loans are based on income streams, revenues, and things like that. There is no real effort with the banks and the lenders to work out some kind of more favorable situations or provisions for commercial lenders, the same way Gavin Newsom asked the 200 plus banks and lending institutions to do for residential homeowners.
That's
by,
correct.
you know, a forbearance in mortgage payments, which is not a law. It's a voluntary act that the various 200 plus financial institutions agreed to do on a case by case basis.
Right.
You know, they look at you, your track record, your credit score, your history, and then each person will get a different kind of arrangement. So there's no such arrangements for commercial loans. So, you know, just from a plain common sense and, you know, looking at the economy as a whole in an economic perspective, if you take from Peter to pay John, you know, there's an imbalance somewhere. So, you know, this is a situation that needs to be addressed.
I couldn't agree more. I mean, it's definitely a political solution that I think everybody would like to see happen. We have a couple more questions coming in. From Monica. Can you evict a tenant for nuisance? I have a neighbor who is very loud and keeps waking me up in the middle of the night about twice a week, and the building manager says she cannot evict during this time. I would second Monica's question. I also have a tenant who we suspect is doing something illegal in his unit, and we're getting complaints from other tenants, and I've actually had some other tenants move out, which is obviously costing my client money. But the problem is we're being told from our tenant landlord, our landlord tenant lawyer, is that the California Judicial Council is not issuing summons right now. So you can't even file an eviction. So what is your response to Monica and myself?
So, you know, see, this is what, when I said earlier, this is the most complex, convoluted set of laws. This is why. So under the LA County moratorium, you can, if the tenant is creating a health and safety issue, right? And that's what's in the slide where it says, except if it's creating a health and safety issue, right? You can have the tenant evicted, right? But if the nuisance is because they have more people staying in the house or more pets because of COVID, and that's a noise, you cannot evict them because of that. But any unrelated health and safety issues, right? If it's a health and safety issue, you can evict a tenant. So,
so noise in this case would not be considered?
Unless you think it's a health and safety issue, but some of the lawyers believe that nuisance that's not related to COVID, right? Because if you look at the moratorium, it specifically says if it's the nuisance is due to noise or the number of occupants on the premises that is caused because of COVID. Somebody else got evicted, 3 families move in together because they're related, and mother and 3 children, and they have wives and grandchildren. Then that's COVID related if they lost jobs and things like that. But I think there's an argument to be made that if the nuisance is not COVID related, you could file a lawsuit against the tenant. But you're right, and this is why it's confusing. The Judicial Council of California issued this rule in early April or early May, somewhere in April, that said they would not issue summons on evictions for 90 days after the emergency was over. So, I don't have, let me see if I can pull up the details on that, but I'm not sure if that's a blanket no eviction.
My understanding is that it was, is that they were literally not hearing eviction cases. Like COVID, non-COVID doesn't matter. That's what we were told, but I'd be curious.
So the issue is that I don't think it's correct to say the court is not hearing eviction matters, right? Because if it's a health and safety concern, right, you can go to court for an eviction matter.
Okay.
Right. And so there's an exception in the moratorium. It clearly says if it's a health and safety matter. The Judicial Council of California, wait a minute. Sorry. So yeah, I think, you know what, let me just go to my firm's website because it's on my firm's website. And my fact sheet is there. So let me pull it up because yes, there is a ban. The Judicial Council of California will not issue summons. So you can file a lawsuit, but it's not, the issuing summons means it's not going to get served on the tenant. And the clock for the tenant to answer does not start to run until kind of the, until the summons are served. If you have another question, let me know. I can.
Yeah, I have a couple other questions.
Sure.
Again, from Mary Allen, who once again is a property manager. How realistic is it an eviction case will proceed in the court system for non-COVID related at-fault evictions? We have a tenant causing disturbance impacting health and safety of other residents. So it's very similar. It's the same question.
So
I mean, let me ask you, has your firm taken any cases to court that are non-COVID related, that disturbances causing health and safety? Have you guys personally done it yet?
See, we don't do UDs, which is unlawful detainers.
Right.
Right. There's a whole separate
of course, yeah,
kind of law that,
yeah.
And they're too small in some ways. Kind of my firm doesn't do that. But I agree with you that if the Judicial Council of California is not issuing summons, that's going to be a problem, even though the city or the county says yes. So what I would do is I would file my lawsuit in court. I would go and talk with the clerk of the court and say to her, the county permits me to do this. I'll have your attorney, of course, do it. As the county permits me to do this, but I don't have. But the Judicial Council, the state of California is not allowing us to issue a summons. How do you plan to resolve this? So I would definitely ask for that.
Okay. Somebody, Michael just wrote, you can go ex parte and raise health and safety concerns. Our firm has been successful in getting these granted. Can you explain what ex parte means?
Yeah, so that's interesting. An ex parte means you go on an emergency basis. An ex parte means it's an individual communication with a judge. That's the Latin phrase, that what it means exactly. Normally you have to have both sides before a judge and both sides talk, but in this case, one party goes into court. So I guess the question is, are you going in on a civil suit for, maybe it's a civil suit for damages, or it's like an eviction proceeding, and you ask the judge to, give you emergency relief. You can do that.
Okay.
So I'm not, and Michael can say that, whether maybe you can put in the chat box, whether they go on as just a civil action or it's an unlawful detainer.
Mm-hmm. Michael, feel free to let us know. Let me ask you a question. You mentioned unlawful detainer, you just wrote.
Right. Oh, okay. So that's good.
Okay. So let me ask you, you mentioned that your firm represents, landlords, and I assume a lot of them have commercial tenants. Like
we represent both landlords and tenants. So we have some,
landlords and
yes,
tenants.
because we can have, because let's say, I'm just throwing out an example. Hulu is also a tenant, right?
Correct.
You can be a multinational company. Hulu's not our tenant, our client, but you could be a tenant as well. So we represent both tenants and landlords.
Right. Now I'm, for instance, a member of the Silver Lake Chamber of Commerce, and a lot of our members in the Chamber of Commerce are having problems, and we're being called. We have for instance, there's a gym in Silver Lake that's been there for many, like decades, like 40 something years. And they're having issues with their landlord. Like they have a $20,000 a month, nut, right? And they're a gym, so they can't open, right? By government order. And, like in that type of scenario, and I mean, we've had restaurants say the same thing to us, there's various things like, what can tenants do in this scenario, when they're ordered by the government to close? Like, what are their options, or what have you been counseling them on a general basis?
So see, the tenants have to follow exactly the eviction moratorium that we discussed, right? You have to talk to your landlord. We always advise our tenants is talk soon and talk early, because now we have 3 months into it, but the people who went early got better deals because the landlords, it was new for everybody, right? And so the people that came later, the landlord had already made a bunch of deals and reduced whatever, did forbearances for a bunch of tenants, and was now going, wait, I can't do that anymore for the stragglers. But what we encouraged the tenants was to go early, write to the landlord, document your COVID-related reasons for non-payment of rent. And in one of the reasons that a tenant has to give a landlord is including saying, we're a school, we're closed, we're a gym, we're closed, or we're a restaurant, we can open, but it's only takeout. It's not in within premises dining. So you present that information and those ordinances to the landlord, and then you say to the landlord, ideally, either we can't pay rent at all, or we'll pay a portion, or you work out whatever arrangement. Technically, you don't have to pay rent to the landlord. Right. It will be due when the moratorium is over. And right. And my sense is that if you don't pay it then, and you just up and leave the property, the landlord can still come after you in a civil lawsuit for damages, because it is an amount of money that's financially owed. And if your lease agreement had an attorney fee provision, the landlord can also ask you to then pay the costs of his having to sue you to get the money back. Right now, some tenants will go into bankruptcy, and then that puts a stay on any eviction proceedings, and then that's a whole nother ball of wax. Right. But tenants the tenants have tremendous protections right now. So, you avail of those protections, you document. That's the one thing I would say, please document it. Keep whatever you're providing to the landlord in one place, every written request, whether it's a text or an email, talk to the landlord. I would suggest, send emails to landlords, preferably don't text, because it's hard to copy and save them later.
Okay. Couple more questions. This is from Kelly, who's a client and an agent at the collective. Yes, we were talking about lenders earlier. The lenders are not cooperating in tandem with protection for tenants. So it doesn't seem valid unless mortgage protection can be enforced. Is the same ruling, I'm assuming she's talking about the eviction ruling, still in place for short-term rentals in LA? At least you get paid up front in those cases.
Uh,
So say you have an Airbnb that you're whatever, a short-term rental that you have, and basically then they decide not to leave, right? After say you have a week-long rental, then they're supposed to leave. What if they decide not to leave? Do those tenants still have the same rights as any other?
I don't think the Airbnb folks will get covered under the rental, these agreements, right? So here's what I would say. It will depend whether there's a landlord-tenant relationship, right? And then, you know, how it's an oral lease, it's a month to month, and it was there for a year and it continued after that. Or if there's no rent, but a person is there for more than 30 days, you know, it's kind of those provisions.
Right.
Um,
Because
so
yeah,
I,
with an Airbnb or VRBO, there's no lease, right? It's just you're paying. This is my daily or weekly
and I
amount. If you pay this.
cannot remember because I don't think that the ordinance actually distinguishes between short-term and long-term.
I'm not aware that it does.
You know, you also have to remember that the ordinance that came out in July was also based on the one that came out in May and the one that came out in June and the one that came out in March. So they reference each other and then they add on provisions to each other. So you kind of literally have to go back and, you know, see, but, you know, unless your short-term tenant ends up staying for a really long time, and he ends up becoming a deemed a tenant due to passage of time and under the tenancy laws, you know, then you might be able to say, yeah, he is, and go after him. But I also thought that, you know, there are pretty big deposits and access to credit cards, you know, payments and things like that. And so, you know,
Yeah, it
maybe
might be
landlords
something
can
they can
use.
go through the company, through the Airbnb or through VRB or whatever company that they rented through. You know, they might
Right.
have some type of, yeah.
Oh, so I am looking at my, and again, my firm's name is Alvarado Smith, and that's ALVARADO SMITH, Alvarado Smith. And if you Google them, on their website are these moratoriums, and it says that the Judicial Council of California will not issue summons except to protect public health and safety.
Hmm.
So if it is to protect public health and safety, then the courts are issuing summons.
Okay, that's good to know. That's very good to know.
Well, you should be reading my firm website, you know, alerts and memorizing them.
Absolutely. We have one more question from Diana. What if the tenant doesn't respond to any communications about non-payment of rent? Are landlords required to give any notices for non-payment of rent?
So what we are asking landlords to do is to inquire, because under the moratoriums, if you demand rent, it could be seen as intimidating or harassing the tenant. And then if you have, you know, it's possible for the tenant to come back and say, well, my landlord harassed me. So, you know, in a lawsuit or, you know, things like that, even if you file the unlawful detainer. So we have been advising our tenants landlords to ask the tenant, right? And I would document this. I would, you know, write to the tenant and say, you know, the letters I've drafted have said, you know, we really care about our tenants. We understand this is a difficult time. Everybody's going through this, you know, things like that. We want to do everything we can to protect the well-being of our tenants. We want to know how we can work out financial arrangements. So can you please tell us, you know, what the financial impact is on you, if any, you know, what your situation is in terms of rent. Would you be able to pay partial rent or not? Is there an arrangement we could work out? I would frame them in the way of asking questions, not a threat and not a demand, because it's going to come back to bite you in the butt if you try strong arm tactics right now. You have to remember we're in a state of emergency. It's been declared at every level from local government all the way up. You're not going to find courts are going to be very sympathetic with you if you went in and said, hey, you know, I'm the landlord, I need to get paid rent, I'm going to do what I want. The judge is not going to be pleased with you if the matter ends up in court, and it could cost you financially. So from a financial perspective, the most prudent way to get your money back and to move ahead in these times is to have a conciliatory tone with the tenant, meet the tenant halfway, and document this. If your tenant doesn't respond, right, send them by certified mail. If you have a valid email, send it by mail, send an email. Don't just put regular stuff in the mail, send it certified mail. And this is just a 2-cent thing. There are certain online post office, USPS websites where you can send a certified letter, and the minute the letter is delivered, there's a tracking number, a barcode, you will get an email saying it was delivered. So even if somebody doesn't sign those old-fashioned certified receipts and sends it back to you, you have confirmation that the notice was delivered to the tenant. And, unfortunately, this is the way the moratoriums work. If the tenant doesn't respond, all you can do is document every month, every 15, 20 days, a positive letter, inquiring, and, just keep doing that.
Yeah, it's very challenging right now. We definitely have situations like that where tenants are not responding, despite our, and we always try to put it in those exact same terms. We're trying to work with you. We want to figure out, we want to find out like what's going on, and is there a way we can, work out some type of a system. But you can't, like you said, you can't be threatening about it. You can't be,
No.
And it doesn't behoove anyone in this scenario. But it's challenging. It's challenging times.
It is. And the reason why you can't do it, because it's a misdemeanor. It's, if the moratorium did not make threatening writing to the tenant to demand rent a misdemeanor, I would say, what lawyers write in pretty confrontational language all the time, right? But the landlord has to be careful, because the moratorium did include specific sections and language saying that it was a violation to do that. And because of that, we've been advising our clients or landlords to be careful.
Yeah, we've been advising our clients to do the same. Whenever we're as their property management company, have been trying to do the same. We do, however, one thing, and this we heard in another webinar from other landlords, was that we do include the amount that's due.
Yes.
And that sometimes, just as they see that number grow, sometimes that may encourage them to be like, well, you will owe this at some point.
Right.
It might not be today,
right?
But it will be at some point. You will owe this. And when those numbers start to really grow, as they have been, right, we do have some tenants who haven't paid for 5 months. And they're what they owe is now in the tens of thousands of dollars. And so that often will prompt them to make some type of payment. Sometimes it's also working with your tenant. Like we do have a commercial tenant that's a restaurant, and we've allowed them to open up in our parking lot. They've taken over 3 parking spaces, and we are okay with that, because that way, they can at least operate a business, and I got a check afterwards.
Right. And
So,
also, the moratorium provides that the tenant owes the money, one, and there's a certain time frame. So you cannot add interest or cost when you're telling the tenant, okay, it's month 5, it's now X multiplied by 5. Month 6, it's X multiplied by 6, right? You cannot include any costs or late fees. But you can put in the letter and say, if the rents are not paid at the end of the moratorium within the time allowed, then the landlord can go back and tack on all the costs, late fees, interest, whatever is there based on the lease provisions, right? So the moratorium has very slight benefits for the landlord, that says, if you don't pay, let's say, you're in the 10 to 100 category, you don't pay your rent in six months after in 6 equal installments, or whatever the arrangement is agreed to by the landlord, then every other charge that the landlord couldn't have charged can now be added on if you don't comply and pay within either the 12-month or the 6-month period. But I think just, getting bits of rent from the tenant is better than nothing.
Agreed. I couldn't agree more. Mary, once again, who works for another property management company, wrote, "We have enlisted our attorney to write nice reminder letters on firm's letterhead to uncommunicative tenants." So that's basically what Monisha just said. I don't see any other questions, and we're getting close to, we're getting close to 6 o'clock. Are there any final words that, Monisha, that you want to share before we close up?
No, I think we've discussed pretty much everything. I know this is a really tough time if you're a landlord and you have tenants who rent and who are not paying. Um, and so I would encourage you to document all your communications with your tenants, keep track of those, put them in a file separately, maintain them, get good legal advice, because you can run afoul of the laws. I mean, I get confused between them. I mean, I had to go back because initially California state had rules, then the Judicial Council of California came out, then LA County and LA City were different. At least now the county of LA and the city are the same. So it's not clear, and it is a tough time, for those who don't have money and can't pay rent, and then for landlords who are not getting their money back. So, good luck to you. My emails are, I think, on the slides. I don't know if you can,
We can share that. One last thing, there is one last question. For new tenants moving in, are there any additional issues that we need to address?
So I know lots of landlords have multiple caveats for new tenants about COVID and things like that. Um, so my email address and my phone number are there. I would say if the tenant stops paying rent, and they became your tenant during COVID, the moratorium will still apply to them. So, 6-month deposit, though, you're offering 3 months free rent. So, it's a tough situation. And what was the question again?
The question was, are there any things with new tenants that we should just be aware of, or we should institute if we're renting to new tenants, given this kind of new landscape that we're
right
doing?
See, you have to recognize that you will still be governed by these new moratoriums, and if you think the tenant is going to be a bigger headache by getting in there and not paying rent, or by getting in there and being a nuisance, I think we're advising landlords it's better to keep your property empty for a while rather than have a tenant that you have to then spend a bunch of money to evict and get out of there. So if you're desperate and you're taking anybody in, in the long run, it's not going to benefit you. We say that for attorneys, right? A lot of people sometimes will not pay our fees and walk away. And it was better to have just done nothing during that time than have done something where you're not going to reap the benefit of it, or it's going to be more costly for you at the end. So it's definitely a cost benefit analysis. You have to think through it carefully. And remember, the moratorium will apply to your new tenants as well.
Correct. So as everybody can see, this is Monisha's information. That's her phone number, her email at Alvarado Smith. They do send out great information, on eviction moratoriums. I've just put my own information in the chat for anybody who's there. Best way to communicate with you. We just answered that. So feel free to email or call one of us, either of us, for your various needs. We're getting a lot of calls during this time. A lot of people, I think, are realizing that they may not, because of all the changing landscape and the rules, they are starting to reach out to property management companies. So, our docket's getting pretty full. And also on the sales side as well, a lot of people have been asking us about valuations and whatnot.
I'll just say quickly, you can also connect with me on LinkedIn. You see my name, Monisha Coelho. You can connect with me on LinkedIn, and I have my email and my phone number in the contact info side on LinkedIn. And I also post a lot of these alerts I do on LinkedIn. So that's another way if you want to have access to them.
Same here. Monisha, thank you so much for your time and your expertise. We had a really strong turnout today, and that's, I think, so much because of the topic and your expertise. So we really, really appreciate it.
My pleasure. Thank you for having me, Will. This was great.
Okay. Look forward to seeing everyone next month. Next month, we're going to be discussing a very interesting topic for a lot of folks, which is tenant in common conversions, TIC. And we're looking forward to having Andy Serkin, who's considered the godfather of the tenant in common play. And it's becoming very, very popular, especially for a lot of landlords who may be looking at getting out of the landlord game and maybe, selling off individual units. And I'm involved in a project right now that's with that. So we'll be talking about that as well. Once again, Will Tiao with the Collective Realty. Thank you so much. And we'll see you next time.